So briefly, I want to touch on a medical malpractice case that we recently resolved. The case arose from a birth injury. The allegations were that an OBGYN or two OBGYNs that worked for a clinic failed to perform a timely C-section. There was also an allegation that one of the doctors was leaving, her shift was over, and she didn't give proper instructions to the incoming physician, which is a communication error, and that's actually one of the largest or most often causes of malpractice, is a failure to communicate. And that's one of the things that happened here. Ultimately, the second doctor came in, didn't realize how far along in the delivery process the mother was and some of the complications that she was having during the delivery, and failed to do a C-section. It was too late when he realized that he couldn't do a C-section and that the baby needed one, so he had to use a vacuum delivery. As a result of the vacuum delivery, this young baby developed an aneurysm which ruptured some 30 days after her birth and ultimately led to a brain injury. So the case was litigated for approximately 3 years and ultimately settled at mediation earlier this month. And as part of the settlement, today we had to go in front of the judge and request his permission to approve the settlement. The judge, prior to going to the hearing today, appoints what's known as a guardian ad litem, and that's to make sure that the settlement is in the best interest of, in this particular case, the minor child. The guardian ad litem wrote a report to the judge, and the judge reviews all the documents in the case, including what's known as a closing statement, which shows what the recovery was for this minor child, what the funds are going to be used for, and make sure the attorney's fees and costs are all in line. And once that happens, the judge will then sign an order approving the settlement, which is what happened today. And that's a safeguard that we have in all our cases involving minor children. So all the courthouses require settlements over $15,000 to be approved by the court. The funds will be used to purchase an annuity, which will provide a stream of income to our minor plaintiff for her life. The other funds will be placed into what's known as a special needs trust, which will provide her further protection and ability to continue to receive certain benefits, whether it be government benefits or insurance benefits. So that's just a little bit about medical malpractice or all sorts of personal injury cases involving minor children that then ultimately require a petition to approve a settlement. Thanks.